I wanted to welcome everyone today to the Burness Paul and Lex Mundy webinar on global mobility, doing business in the UK. My name is Lauren Smith, and I'm a part of the global markets team here at Lex Mundy. And my remit with our global practice groups is to work on resources and meetings that we produce for our member firms and corporate counsel. And I'm glad to be here today with Burness Paul, who's the exclusive Lex Mundy member firm for Scotland, on this co-hosted webinar that we brought together to highlight some of these trending issues around global mobility with employees in the UK. I'm just going to take a few minutes to go over Lex Mundy, what we're about, and how we're structured. So if you're not familiar with Lex Mundy, we are the largest global legal network of independent leading law firms. So in total, our membership is about 150 member firms in over 100 countries. And that means we represent about 22,000 lawyers. Our member firms do have a long track record of working together and providing coordinated cross-border legal advice to clients all around the world. And as the indigenous firms in their home jurisdictions, all of our Lex Mundy member firms possess the in-depth local knowledge and the intel of on the ground in-depth intel that clients are looking for. And our member firms are selected on maintaining their top tier reputation and offering full service capability in their jurisdictions. Next slide, please. So in 2002, Lex Mundy launched Equisphere, which is our service model that helps corporate counsel address significant cross-border legal challenges. And we developed Equisphere as over the last few years, we talked to about 200 GCs, kind of both in informal and formal conversations about their legal needs and within their legal departments, but also as a more formalized survey about their pain points and their frustrations that they experience with external providers like global law firms and big accounting firms, as well as independent law firms when they're working on cross-border projects involving multiple jurisdictions. And the feedback that we consistently heard from these GCs, it was very difficult to find providers who have the correct coverage and the consistency of quality across the jurisdictions where they need it. And many providers don't have the right geographic coverage, and where they do, the quality might be inconsistent. And the other frustration that they shared with us is unpredictability with cost. And that's not necessarily high cost, but it's just a lack of transparency in cost. And that's often caused by insufficient scoping at the start of a project. And in particular, when there's so many different work streams and different law firms working on one project. We also heard from corporate counsel that there's limited transparency when it comes to things like status of various tasks, deliverable, work streams, and budgets. When there's so many different work streams and things to keep track of when working across multiple jurisdictions. And that's often because there's a lot of gatekeeping by the lead firm that unfortunately results in things like missed deadlines, as well as sometimes going over budget. So after this market survey and the consistent pain points that we heard, Lex Mundy designed Equisphere to deliver a better experience of delivering cross-border work in a more simple, user-friendly way and a better approach for clients who are working with multiple member firms on cross-border projects. It also allows clients to design their ideal global law firm based on their legal matter and jurisdictional coverage. Next slide. So this is just a quick snapshot of what it looks like to work with Lex Mundy and to work with us sort of inside our Equisphere project model. And it means that you have access to leading firms across the entire footprint with consistent quality. It means you get smart legal project management using agile Kanban methodology. You'll get a single point of contact with the lead Lex Mundy member firm who is supported by Lex Mundy project management. You get consolidated reporting across the firms. Through our Equisphere model, we can offer a transparent online portal. So you have transparency with all work streams, with all the firms you're working with, and all the budgets according to the member firms doing the works on the matters, and they're updating their budgets regularly. So you can track where they're at on budget costs. You'll get ongoing support and quality assurance, as well as streamlined legal advice to ensure cost efficiencies. In addition to the service that's provided, when you're working with a Lex Mundi member firm, there's no fees for coordination, as this is part of the Lex Mundi membership model that we can offer to corporate counsel. So in addition to Equisphere, I just wanted to kind of quickly touch on, the overview of what we have in our resources. But in addition to what I just talked about, Lex Mundi does have very active practice groups as well, including our labor and employment group and our tax practice group and our immigration practice groups, some of which you'll hear from Burness Paul today. But the members of these groups do have a wide variety of experience in handling cross-border matters through the Lex Mundi network for global clients, and they often work together on cross-border matters. In addition to the collaboration on client matters, the group also produces a lot of resources, both for member firms and corporate counsel. One is our Global Employment Law Guide, which compares major areas of employment law across 70 jurisdictions around the world. This access is available to you on the Lex Mundi website. And the groups also regularly host roundtables for clients to give short updates on market activity in their respective jurisdictions and regions and upcoming significant regulatory developments to be aware of. So that's the overview of Lex Mundi today. So if you do have any further questions about working with our practice groups on cross-border matters or using Equisphere, please feel free to contact me for further information. And with that, I'm happy to hand it over to Andrew with Burness Paul to start the content.
Thanks very much, Lauren. Good morning, everyone. I don't often get to say this, so I'll start off by saying I hope wherever you're calling in from, it is as beautiful a morning as it is in the northeast of Scotland. Perfect blue skies out here as I look out across the North Sea. Pretty rare, so we will take it while we can. As Lauren said, my name's Andrew. I'm Andrew Knight. I'm a partner in the employment team here at Burness Paul, and I'm delighted to be joined on this webinar by my colleagues Nikki Weir, who is a director in our business immigration team, and Christine Yule, who is a partner in our tax team. Burness Paul is one of Scotland's leading commercial law firms, and we've got offices based in Aberdeen, Edinburgh, and Glasgow. And although we're Scottish based, and as Lauren explained, we're the exclusive member firm of Lex Mundi from a Scottish perspective. From a wider UK perspective, we've got strong English law capabilities in all key disciplines, including dispute resolution, commercial property, corporate finance and M&A work, and we regularly represent clients in England, Wales and in Scotland. Nikki, Christine and my practice areas, being immigration, tax and employment, are all areas which are largely reserved for the UK government, so the rules are the same in Scotland as they are in England and Wales, with the exception to that being tax, where Scotland holds some of its own tax raising powers, as I'm sure Christine would explain far better than I. And that's why I think this topic today around doing business is around doing business in the UK rather than doing business in Scotland. We're delighted to be co-hosting this webinar with Lex Mundi. As Lauren said, we're the exclusive firm for Scotland, and we've been a member of the Lex Mundi network for a number of years now. And speaking from a personal perspective, and certainly from the firm's perspective, I've seen the huge benefits to our clients in terms of being able to access best-in-class legal advice across the globe. And that advice really is so well coordinated through the network. We've also seen huge benefits to our firm in terms of the opportunities that it opens up to us to collaborate with high caliber lawyers in overseas jurisdictions. I was just over in Houston a few weeks ago and met up with Lauren and some of the other Lex Mundi gang and some of the member firms. So fantastic opportunity it gives us as lawyers to do that, and also gives us the chance to work with exceptional clients who are looking to do business in the UK. So although we're Scottish based, we have a truly international reach, and a significant proportion of the work that we do is cross-border and involves collaborating with firms in other jurisdictions, or has some international element to it. And that, of course, brings me on to today's topic, which is global mobility doing business in the UK. I'll start by saying that the United Kingdom has always recognised foreign investment as one of the key factors in economic growth. And whilst none of us can pretend that the last few years have been politically as stable as we might have hoped within the UK, we do remain a highly stable and transparent regulatory environment for attracting foreign investment. So our focus today is going to be on the people side of doing business in the UK. I'm going to hand over first of all to Nikki, who is going to talk about the routes available to businesses looking to bring overseas labour into the UK. And that could be businesses who are established in the UK looking to supplement their domestic workforce, or foreign businesses which are newly established within the UK looking to bring in overseas labour. Next, Christine is going to discuss the taxation implications of engaging employees to work in the UK. And I will conclude with a discussion on the employment and labour law regime which applies to workers in the UK. And then, as Lauren said, we'll hopefully have some time at the end to take some questions from the audience. As a real test of my multitasking ability, I'm going to try and monitor the chat box as we go through this. So feel free to type questions as we go along. I know it's sometimes easier to do that in the moment rather than storing them up for the end. So if you type them in the chat function, then we'll try and address as many as we can at the end. I suppose we wouldn't be lawyers without kind of caveating things by saying, look, we've got an hour and a half today for this webinar. And within that time, we unfortunately won't be able to give a comprehensive overview of all of the rules that exist within these three areas that we're going to discuss. If it was possible to learn everything you needed to know about immigration, tax, and employment within that time frame, then it would be pretty worrying, I think, for Nikki, Christine, and my respective practices. But what we hope we can do within this time is to just help your businesses and their clients understand what you need to focus on and where you need to take advice when looking to do business in the UK. And then kind of final thing from me before I hand over to Nikki, I should mention that we are going to be publishing a more comprehensive guide at some point this year on doing business in the United Kingdom. This is a guide that we've developed. We've been supported by the UK Department for International Trade in developing this guide, and it's got some great content within it. So details of that will follow in due course, and access will be made available to those attending this webinar once it's ready. So watch out for that. So without further ado, I will hand over to Nikki, who is going to talk about immigration.
Thank you, Andrew, and welcome everybody. So I suppose that immigration seems like the obvious place to start when considering basing workers in the UK. Obviously, as Andrew said, we're not going to be able to cover everything, but my intention for today is to really get across the message that the UK is, despite Brexit, we're still very much open for business internationally. And whilst I can't, go into great detail about every single visa option, I'm planning on going through the visa categories that we see most often used by our clients and which we think might be most useful for you. I'm happy to go into more detail if anyone's got any follow-up questions. I suppose starting somewhat with the negatives, the UK is perhaps somewhat lagging behind some other countries in that we don't at present have a specific sort of digital nomad type visa that I know some countries have introduced in light of COVID. Obviously, the way we work has changed. We work more flexibly, we work often remotely, and I think a lot of people had cause to assess their life choices during COVID. And you know, understandably, a lot of people thought, you know, if I'm working remotely, I don't want to be based where I am. I want to go work for 2 years in the Scottish Highlands. We had lots of queries around that sort of working, and unfortunately we don't have a specific visa that's geared to that at the moment. That may well change, so that's something to I suppose keep an eye on. But unfortunately we don't have that at the moment. We do, however, have lots of options. So I'm going to run through at the moment, starting out with the visit visa. So I suppose, again, a bit of a warning shot that this is the category that we quite often see misused by overseas workers, quite unintentionally usually. But I think it's important to have an understanding of when a visit visa might be appropriate, and when it would be appropriate to look at a different type of more specific work visa. So I'll start out by saying, and you'll see in my slide here, I've underlined this, that non-visa nationals are still bound by the visitor rules. And I think this is where we see often a lot of people getting caught. A lot of non-visa national visitors come to the UK, and by non-visa national I mean countries that are specified under our immigration rules as not requiring a visa just to visit the UK. So for example, we've got EU countries, Australia, USA, that sort of thing. They are able just to visit the UK, don't have to apply in advance for a visit visa. The fact they don't have to apply for a visit visa doesn't mean that they are excused from complying with the visitor rules. And I think that can often be a sort of general misunderstanding. So anyone that enters the UK as a visitor is bound by the visitor rules, whether or not they have had to apply for a visit visa in advance. And that then means that you are precluded from carrying out business activities other than those that are expressly permitted by the immigration rules. And again, I think that that's something that can perhaps quite often go under the radar for a lot of workers coming to the UK. They're perhaps not aware of the very tight restrictions that there are on visitors carrying out work in the UK. Generally speaking, you can't work unless you're carrying out one of the very expressly determined business activities in the immigration rules. You cannot use a visit visa for successive visits to effectively base yourself in the UK, or base yourself between another country and the UK. So we have seen, for example, workers maybe coming over, spending 3 months in the UK, come back to their country where they're based, and then coming back again to the UK for another few months. That's generally something that, whilst you might get away with it for a while, the Home Office are going to catch up with you on, and it can cause difficulties further down the line. Generally speaking, you can't receive payment for work carried out in the UK. There are, of course, some exceptions to this, but generally speaking, you can't be paid for work carried out in the UK. And you are expected to be in the UK on a short-term basis. So although as a visitor you can technically be in the UK for up to 6 months at a time, in practice business visits for the permitted business activities would tend to be a lot shorter than that. And if questioned at the border on your intentions, and you say that you're planning on spending 4 or 5 months in the UK as a business visitor, that's going to raise a red flag with the border agent. So not to scare you, the business visitor route is an excellent route, and when used correctly can be a really good tool, but it's important that it's used correctly. So if, for example, you are based overseas, work for an overseas company, don't have any other type of leave to live and work in the UK, you're coming as a visitor, it's absolutely okay to come over for a short term, do activities such as attending meetings, conferences, You can negotiate and sign deals and contracts. You can attend trade fairs. You can come over here to gather work for employment overseas. You can be briefed for the requirements of work for a UK-based customer. You can consult, troubleshoot with a linked entity in the UK on a specific project, that sort of thing. But you cannot simply come over, you know, for example, if you work for a company that also has a UK linked entity, you can't simply come over and base yourself in the UK office for, you know, a few weeks, months, unless you are carrying out one of these permitted activities. So if you take nothing else away from my session this morning, I think if you're coming here on a business visit, make sure what you are doing when you're here fits within the business, the permitted business categories under our immigration rules. And it's always, I think, a good idea to have an itinerary. So if you are questioned at the border, then you've got something that you can show the border agent. I'm here to attend these meetings, this trade fair. I've got this meeting. I've got, you know, I'm attending to sign this deal, so that the border agent will be satisfied that what you're doing is permitted. Could I have the next slide, please? So that being said, whilst your business in the UK may well fit under the visitor category, if you're coming for longer term, or you're not coming for a specific purpose, you're coming more to base yourself in the UK for work purposes, then the likelihood is that you are going to need a more specific visa. There are many visas, and I'm not going to be able to run through them all, but as I say, I'm going to sort of cover the ones that our clients use most regularly, starting out with the sponsor license category. So this is relevant for companies that may be based overseas but have a UK linked entity, and they're looking to transfer staff between the two, or they're looking to hire staff from overseas to base in their UK entity, or for companies that have an overseas established organisation and are looking to expand into the UK. So there's different types of categories under the sponsor license umbrella. So split into sort of workers for skilled and long-term employment, and temporary workers for specialist and temporary employment. So worker license will let an organisation sponsor people in different types of skilled employment. And that can be, although it's sort of touted as a long-term route, you can bring over skilled workers for, you know, a couple of months if that's all you need them for, or for more permanent employment in the UK, and it can be a path to settlement if you're looking to transfer somebody over here permanently. We've got the skilled worker route, where the role must meet various job suitability requirements. And we've got the senior or specialist worker global business mobility route, which is a bit of a mouthful. That used to be known as the intra-company transfer, ICT route. I can't quite get my head around the new terminology, but this is effectively for multinational companies who need to transfer established employees to the UK. Now, in reality, I think we're seeing a drop-off of usage of this intra-company transfer route, solely because it is quite restrictive, it's quite temporary, and the salary thresholds and things are significantly higher for most roles than they are for the general skilled worker route. So quite often we see companies that are in practice transferring staff from overseas to the UK, but they'll still use the skilled worker sponsor route rather than the intra-company transfer route. Where we see people tend to use the intra-company transfer route still is where they're looking to get somebody over quickly and they might not meet the prescribed English language requirements. You can sort of get around that by using the intra-company transfer route, and then potentially once they meet the English language requirement, you can switch them into the skilled route if you want to have them here on a more long-term basis. So quite often when companies are applying for a sponsor license, they'll apply for the two categories under the worker route, the skilled worker and the intercompany transfer, or which is now the senior or specialist worker route. I think we've really seen an increased use of the sponsor license route post-Brexit. Certainly a lot of companies that maybe would never have previously considered using a sponsor license, but perhaps relied quite heavily on European migration, will or have been applying for sponsor licenses. We do certainly recommend, for countries with for companies that are likely to be transferring staff, or that will be have a UK-based entity and will be recruiting from out with the UK, we would certainly recommend that companies do consider applying for a sponsor license, even if they're not imminently employing anyone. There's quite a lot of background work in actually applying for the license. Once that's in place, it lasts for 4 years. It can be renewed. The renewal process is much more straightforward. And it means that if you are in a position where you're needing to transfer somebody or recruit somebody from out with the UK, you've got the license there, and you can do it a lot more quickly. I just had a wee look, so that the Home Office have a register of sponsors that they update almost daily. And at the moment there's just under 80,000 sponsors registered in the UK. So you can see that it is a route that is used a lot. It has, I've been practicing in immigration law for longer than I would care to admit. And my experience of the sort of skilled worker route is that over the years it has become much easier to use. Historically, it was very cumbersome. It was a bit of a faff to sponsor people under the route. The employers had to jump through a lot of hoops, and that has gradually become a lot more straightforward for companies, which probably a concern for immigration lawyers like myself. The easier it becomes, the less need there is for us. But certainly for employers, it's becoming less of a task to use the sponsor system. And certainly, if anyone wants to ask any questions about it, or wants to follow up afterwards and have a chat about how a sponsor license might benefit their business, then I'd be more than happy to discuss. The temporary workers umbrella of the sponsor route can let you, it does what it says in the tin, hire people on a more temporary basis. It is quite specific, so there's various subcategories under the temporary worker umbrella, which I'm not going to run through them all. But for example, we've got the graduate trainee. If you've got a graduate trainee program overseas, you've got a UK entity, then you can transfer graduates as part of their program to the UK for a short period of time. We've got the secondment worker global mobility route, which might be of interest for workers transferring from overseas to work for a different UK business as part of a high value contract. So that certainly may be of interest to some overseas businesses. If they're working with a company in the UK, then there may be scope, if that company holds the relevant license, to transfer secondment workers under the sponsorship category. One area that is quite new that has been introduced recently is the UK expansion worker category. Now this, some of you may be aware of her old sole representative of an overseas business category, which allowed an overseas organisation to send over a senior member of staff to set up a UK branch or subsidiary. That category is now extinct, but the Home Office have introduced the expansion worker category. This never used to be a sponsor category, but it is now. And what that means is that the overseas organisation will need to apply for an expansion worker category of temporary licence. And that allows them then to transfer over a senior member of staff, or up to 5, actually up to 5 members of staff, to set up the UK entity. So that is a really important visa category, and one which worked well under the sole representative route, and from what I can see under the new expansion worker route, continues to be working well, although it now has this extra step of requiring a sponsor license. Under the old sole representative category, there were restrictions in place so that those with high stake in a company couldn't use this route, and that has now been removed. So we're now seeing it used quite regularly for owners of companies to transfer themselves effectively to the UK to set up the UK branch. So a really, really useful category for overseas businesses that are looking to establish a UK presence. I think I could speak about the sort of sponsor category for an hour and a half in itself, but I'll move on now. I think if I could have the next slide, please, to some of the other routes that many of our clients find useful. So unless you've been living under a rock, you'll be aware of our EU settlement scheme for EU nationals that were in the UK before the end of the Brexit transition period. This allows EU nationals to apply for either pre-settled or settled status. So it can be useful for companies that are hiring EU nationals overseas that may have obtained settled status in the UK. So what that status means is that they are allowed to base themselves in the UK, work in the UK, and they'll only lose that status generally, unless they've got any criminal issues, they'll generally only lose that status if they spend more than 5 years outside the UK. So that can be really useful. It can allow workers to work overseas and in the UK, sort of back and forth. Student routes, if you've got I suppose if you've got your eye on somebody who is particularly talented is studying in the UK, then they can carry out some work in the UK whilst on a student visa, although they're restricted in the hours that they can do during term time. Graduate visa has recently been introduced. It's a really effective visa for those that have studied in the UK. They can move into the graduate visa, which is fairly flexible and open and allows them to work relatively unrestricted in the UK for a couple of years, with the expectation generally that they'll then move into one of the sort of skilled worker categories. Youth mobility visa is open to certain nationalities for those aged between 18 and 30, allows them to come to the UK and again work fairly unrestricted, although the short shelf life, and the expectation is that they would move into a different category. Global talent, this is a category that we do use for those who are renowned as being outstanding in their field, whatever that field may be, or have shown great potential in their chosen field. It requires an external endorsement, so they will require to be endorsed by a relevant agency that's approved by the Home Office as being particularly outstanding in their field. And that endorsement would then allow them to apply for a global talent visa, which allows them to work again fairly unrestricted in the UK, although the expectation is that they will do some work in their field if they're planning on extending their visa or settling in the UK. We've got the high potential individual visa, which is a new introduction. That's for those with who have graduated from an endorsed university by the Home Office, a university that the Home Office recognised as being for particularly high performers. If you're graduating from one of those universities, and they're worldwide, and the Home Office update their list regularly as what universities they are including in this, then that can allow people to come to the UK for a few years, again with a view to moving into a more skilled worker category when they sort of find their place in the UK. And the innovator founder route is for those looking to set up a company in the UK. Generally, the Home Office will expect that to be something that is innovative, viable, scalable, and there's quite a lot of background work for this visa application, but once it's made, it would then allow that individual to effectively set up their company in the UK and work here for that company. I've left to last the Frontier Worker Visa because I'm going to put here that it's a hidden gem, because I genuinely think it is. This is I think it's gone under the radar slightly. Whilst everyone seems to know about the EU settlement scheme, I think very few people seem to know about the Frontier Workers Scheme. So that is for EEA nationals that prior to the end of the Brexit transition period had been working for some time in the UK. So that doesn't mean that they were basing themselves in the UK. They could have been back and forth, coming over for a few months, going back to their home country. So whilst they might not qualify for the EU settlement scheme because they haven't been living in the UK, they may well qualify for the Frontier Worker Scheme, which will allow them to continue this pattern of sort of working back and forth in the UK. We've had really good experiences with the Home Office using this. Anytime we've applied, they've been really receptive and have granted the Frontier Worker Permit. So really, really useful tool that I think a lot of people haven't been aware of. I'm very conscious of time, so I'm going to stop there. Apologies for running through that very quickly, but there's so much to cover. And as I say, I'd be more than happy to chat through any of these routes or answer any questions that anybody may have. Thank you so much.
Thanks, Nikki. As Nikki mentioned, and as we all know, over the past few years, employees have been working remotely more often, including in the UK, and possibly unsurprisingly, tax systems, including the UK tax system, has been struggling to keep up with the changes. From a UK tax, from a tax perspective in the UK, there are implications for both employees and employers. So I'll look first at the position for employees. Where employees work remotely in the UK, either temporarily or permanently, the key test from an individual perspective in terms of their tax treatment is determining whether or not they are UK resident for the tax year in question. The tax year in the UK runs from the 6th of April to the 5th of April. And where an individual is UK tax resident in that tax year, then the starting position is that they are subject to tax in the UK on their worldwide income. You will hear this phrase a lot, and don't blame me, blame the government. There are exceptions to this rule. There are some exceptions where the individual in question is UK resident but not UK domicile, so they're kind of basically their home country is not the UK. And in some cases they will only be subject to UK income tax on any overseas income which they remit into the UK. But the starting point for UK tax residents, particularly where they are kind of returning to their home country to work remotely, having taken a period away, is that they will be subject to tax on income worldwide, not just received in the UK. As Andrew mentioned at the outset, there are separate income tax raising powers in Scotland. The highest rate of income tax in the rest of the UK is 45%, and in Scotland it's 47%. So as you can see with those highest rates, individuals will obviously be keen to avoid accidentally or unexpectedly becoming subject to tax in the UK. There are a number of UK residence tests, and they need to be carefully considered alongside the residence tests in any other relevant jurisdiction. So, the most kind of relevant one is likely to be where the employee is leaving, so where they've been working most recently, and or kind of the other most relevant one is where they are, where their home country is, where they're from. And the UK tests are similar to other jurisdictions, but sadly there is not a uniform test across the globe such that you're resident in one country only and you don't need to think about it any further. Where the individual in question is or could be subject to tax in another jurisdiction, the terms of the relevant double tax treaty, if there is one, In most countries, there are double tax treaties, but not every country in the world has one. With the UK, the terms of that double tax treaty should be considered to ensure that no double tax arises in respect of the same income, to ensure that it's not taxed twice. So the first test to determine whether an individual is UK resident is an automatic test, and that is whether they spend 183 days or more in the UK in a tax year. So from that 6th of April to the 5th of April the next year, did they spend more than 183 days in the UK? If they did, they are automatically UK resident. If the test is not met, you then need to go to the next stage in the process, and that is to determine whether any of the automatic tests for overseas residents are met. So if those tests are met, then the individual will not be tax resident in the UK for the year in question. There are 5 tests, but 2 of them only apply in a situation where the individual has died, so I won't have a look at those. And I'll just very briefly kind of go through these, because in practice, you're going to have to look at these very carefully. There are helpful flowcharts which are kind of available, but always make sure you're taking proper advice, because the resident's position, certainly in the UK, and I suspect in other countries, has changed a lot in recent years, and I suspect will continue to change a lot as remote working becomes more common and as each tax authority finds its way in relation to those workers and employees. So the first automatic overseas test is if the individual was UK tax resident in at least one of the preceding 3 years. And if they were, but they spend less than 16 days in the UK and they didn't die in that tax year in question, then they will automatically be overseas. So it's 16 days in the UK. If they spend less than that, but were previously tax resident, then they will not be tax resident in the UK and do not need to pay tax here unless they've got particular UK duties, which we'll look at in a second. The second test is where somebody has not previously been in the UK for at least the last 3 years. And in that case, if they spend less than 46 days in the UK, then they are not tax residents. So they've got a bit longer to be able to spend in the UK without triggering that residence, because they have not been here the previous 3 years. And then the third test that would make them automatically resident overseas is that they work full-time overseas within the tax year with no significant breaks in that period. Obviously, annual leave is acceptable, but nothing more than that. They actually work in the UK within the tax year on fewer than 31 days, and they spend less than 91 days in the UK. So they work fewer than 31 and they spend less than 91 when combined with leave or other periods in the UK. So if any of those 3 tests are met, then they are not resident in the UK. If those tests are not met, then we need to consider whether the second or third automatic UK tests are met. The first one was the 183 days at the start. The second and third are again kind of slightly more kind of complicated in their application. So the second test to be automatically UK resident is if the individual for a period of at least 91 consecutive days, at least 30 of which fall within the relevant tax year. So you have 91 in total, but they can straddle the 6th of April or the 5th of April at either end of the tax year. So within that period of 91 days, they have a home in the UK and they need to be present in that home for some of the time on the 30 days that I mentioned within the tax year. And the individual has no home overseas and no home in which he or she is present for more than, for some of the time, on more than 29 days in a year. So it's basically kind of somebody whose home is in the UK, even if they are traveling about a lot and they don't have a home elsewhere. The third test to make somebody automatically UK resident is that they work full-time in the UK for any period of 365 days, so calendar year, with no significant break from that work. And again, all or part of that period falls within the tax year, so kind of straddling either end of the tax year. And that 75% of the total number of days where they do more than 3 hours of work is done in the UK. And at least one day, which is both in the 365-day period and in the tax year itself, is a day in which the individual does more than 3 hours of work in the UK. I'm obviously not expecting anybody to remember any of this, but it's just very much an illustration to show that there are a lot of tests to go through here, and that's kind of why kind of flowchart system can be a good way of testing it. But it's really kind of trying to catch people who are either here most of the time or they travel around the world a lot, but actually their home is in the UK. Even if you don't meet the first, second and third automatic UK tests, you then need to look at whether the individual in question has what's known as sufficient UK ties. This is only relevant if the automatic tests are not met. If they're met, then you've already ticked that box. If basically there are a number of ties that you need to look at. So you need to look at an accommodation tie. Does this individual have a place to live in the UK for a continuous period of more than 91 days, and they live there for at least one of the days? So it's not necessarily that they own a home in the UK, or even that they themselves rent a home, but the fact that they have a place to live in the UK for more than that 91-day period. If they don't have that, do they have family ties? So does their spouse or civil partner, who they're still with, living as a spouse or civil partner, or a minor child who they see regularly, unless that child is at boarding school, do they have kind of family in the UK who are living here and are resident in the UK? Next tie is a work tie. So do they work in the UK for 40 days, or more? Then there's also a 90-day tie. So again, kind of, do they have more than 90 days of presence, whether it's working or not, in either of the 2 preceding tax years? And then the kind of last one, if you haven't kind of fallen within any of those, is a country tie. So do you have more days of presence in the UK than any other country? And again, there are kind of further rules which flow from that I won't go into, but you'll see that establishing whether an employee is UK tax resident or not is not necessarily an easy task. And you may have to go through similar processes in any other relevant jurisdiction to see again whether they meet the test there. So let's assume that the employee that you have remotely working in the UK is not tax resident in the UK. Sadly, the story does not end there, because even if the employee is not tax resident in the UK, they will nevertheless be subject to UK income tax on any duties performed in the UK. So you may have somebody an individual, an employee who's not UK resident, and if they are only performing duties in the UK which are merely incidental to their other duties in other jurisdictions, they will not be subject to income tax in the UK. But where UK duties are being carried out, so they are carrying out duties in the UK, then again, they will be subject to income tax in the UK, and the terms of any relevant double tax treaty will need to be considered. Because if the country in question is like the UK, where worldwide income is taxed, but there's also tax arising in the UK, we need to try and avoid a situation where the same amount is not being taxed twice. It's important to note that for directors, the rules are slightly different. So if you have one of the company directors in the UK, HMRC, the governing body here, HM Revenue and Customs, determine that if a board attends even one board meeting in the UK, that can never be incidental. So a portion of a director's fees will always be subject to income tax in the UK if they attend even one board meeting there. Again, kind of unhelpfully, the rules for the UK's equivalent of social security contributions, national insurance contributions, are slightly different, and a non-resident director will only have to pay national insurance contributions if they attend they attend regularly in board meetings in the UK. So for income tax, even one will subject the individual to UK income tax, but it will only be the case that they pay national insurance contributions if they're attending kind of fairly regularly meetings in the UK. So sadly, it's never straightforward. And where their duties performed partly in the UK, partly overseas, there's likely to be time apportionment involved. So obviously, from an employee's perspective, it's very important for them to understand if they're being asked to work in the UK or they're choosing to work in the UK, what their position is. But what is the position for the employer? What are their obligations? Could I have yeah, perfect, thank you. Next slide. The residence tests are UK wide, and employers will need to think kind of about all elements of the package that they're offering to their employees to see how they're likely to be taxed individually, and whether or not the employer has any kind of obligations. So it's not just kind of the salary that you need to think about. It's also bonus arrangements, benefits, expenses, things like, are there share options? Are there, kind of share plans, incentive awards, and particularly if an individual, kind of while there's, say, a vesting period, are they moving around the world in terms of what they're doing? How does that work? So all elements of the incentivised package will need to be considered. Where an employee is carrying on UK duties, the employer will be required to pay as you earn, or PAYE for short, income tax to HMRC on a monthly basis if the employer has a presence in the UK. And a presence in the UK is if there's a branch or an office, which are obviously kind of easy to decide or not, but also even if there's just a business address. So it will need to be, again, kind of carefully considered whether what is the employee doing, where are they working, do they have an office, have you taken any space out for them? If so, there's likely to be a presence. If not, is there even a business address that would mean that you would need to register for PAYE in the UK? So that would need to be carefully considered. If there's an individual who is actually kind of working in the UK under the control of another business, so kind of you've seconded somebody out, or they're helping with another business, then in some cases that host employer might take on the PAYE obligations. If neither of those apply, so there's no presence established, you've just got kind of a person working from their home in the UK, working remotely, then that individual will need to advise HMRC of their work, and they may either be requested to operate PAYE system themselves, or potentially more likely they will just simply have to pay UK income tax via a self-assessment tax return at the end of the year. Obviously, from an employer perspective, the onus is then on the employee, but employees are likely to need some help with that in practice. So it's good practice to kind of know what their obligations are, and to either kind of set them up with an advisor, or to help advise what they need to do. The rate at which employee pays tax will depend on their circumstances, and as I said earlier, will depend on whether they're a Scottish taxpayer or not. In addition to PAYE income tax, national insurance contributions may also be payable by the employer and the employee if the employee works in the UK and the employer has a place of business. Again, kind of perhaps unsurprisingly, not unexpectedly, the national insurance contribution rules are similar but slightly different to those for PAYE income tax. So if required, the employer should register with HMRC. It's an online registration now, which is helpful. So it should be kind of relatively quick. But there is now in the UK real-time PAYE reporting obligations, and that can sometimes create a challenge because there can be insufficient time to gather together all the travel compensation data before a deadline. So kind of withholding tax in terms of PAYE income tax in the UK, and potentially also income tax and social security contributions in another host jurisdiction, can end up applying, with a need then to seek recovery under a double tax treaty. So although the process now is quick, which is great, the need to report is also quick in terms of the employer where PAYE is required to be remitted. So that's the employer kind of obligations in terms of employee tax. But what are the implications, sorry, for kind of employers, and in particular companies where they have employees in the UK? If I could have the next slide, please, that would be great. Employees working in the UK can, in some cases, bring an employer within the scope of UK corporation tax. UK corporation tax this year in April increased by 6% to a rate of 25%. So an employee working in the UK can bring a company within the scope of that in respect of some, or in extreme cases, potentially all of its profits. A UK registered company is automatically UK tax resident. That's unlikely to be the case here because we're talking about remote workers in the UK from host jurisdictions. But that's not the end of the story. Again, a company which is centrally managed and controlled in the UK is also UK tax resident, regardless of where its actual kind of country of incorporation is. Again, similar tests to other jurisdictions, but not all have the same tests. And one of the most notable examples to that is in the United States, where there's not the same central management and control residence test. Basically, central management and control is the highest level of decision making. So decisions regarding policy, strategy, and you'll probably be familiar with the fact that, kind of in order to try and stop being resident in a country, you try not to have board meetings there. So if you have board meetings in the UK, then it's likely that a company will become UK tax resident. So normally, if the board meetings are not taking place in the UK, it's unlikely to be UK tax resident. But HMRC will look at the substance over the form. So if actually in practice decision making is being taken in the UK, then the company will become UK tax resident. You may have all the decision making, all the discussions in the UK, but kind of just simply do your board meeting to rubber stamp it overseas. That might not be sufficient. But in most cases, simply having remote employees working in the UK will not make the company UK tax resident. However, again, just with the employee story, it's not the end of the story in terms of liability to pay corporation tax in the UK. So even if a company is not UK tax resident, the company could have a permanent establishment in the UK in certain circumstances. And in that case, any profits from the permanent establishment will be subject to UK corporation tax. If the company is resident, it's taxed on all of its profits. Whereas if it's a UK permanent establishment, it's just any profits from that permanent establishment. And a non-UK resident company will have a permanent establishment in two situations. Firstly, if it's got a fixed place of business with a degree of permanence in the UK, there are kind of exceptions for things like storage units, shops, that sort of thing. So, kind of if you have a shop in another jurisdiction, it doesn't automatically make you resident there. But if you have, kind of an office where decisions are being taken, that sort of thing, then you will probably have a fixed place of business. Again, that may not be the case if you just have a handful of employees working remotely in the UK. The second test can be more relevant though, and that's where you have an agent who can be either an employee, but it could also be an independent contractor. So you may have a self-employed contractor working for you in the UK, and that person has and habitually exercises in the UK authority to do business on the company's behalf, unless they are kind of an agent of true independent status acting in the kind of company's ordinary course of business. It's quite common where that situation arises that companies will have procedures in place and protocols in place to ensure that permanent establishment is not created in the UK or whatever jurisdiction is being kind of talked about. And what they will often do is say, well, if there's a sales agent or an employee working in the UK, they are prohibited from actually concluding contracts in the name of the company. And instead, all those contracts must go through the company's head office for acceptance or rejection. And that can be kind of included as a term of an employment agreement, just to kind of make sure that that individual does not end up accidentally triggering a permanent establishment in the UK. And that's been kind of one of the big talking points in relation to allowing employees to work in remote jurisdictions, working remotely, because companies do not want to be creating permanent establishments in countries that they only have one or two employees, potentially more, but where they do not have a big presence. So just making sure that the agent or the employee is not binding the company. Just a few other points to note, which I won't go through in a great deal of detail at all, but if you have employees in the UK and kind of goods or more likely services are being kind of supplied by them on behalf of the company, then just make sure that the place of supply for VAT, so that's the UK's kind of sales tax, does not end up being in the UK, such that VAT needs to be charged in the UK. A company will also need to consider whether any withholding taxes will apply in the UK. There's no imposition of withholding tax on dividends in the UK. However, withholding tax can apply in some cases to interest payments that have a UK source royalties, rental payments to non-resident landlords, and certain other annual payments. So again, it's just checking if there are, if there's kind of any loans or financing being made in respect of UK operations, that withholding tax is checked to make sure it doesn't apply. If the company does acquire any kind of land interests or property interests, so kind of, for example, taking some office space, then it's likely that stamp duty land tax, or in Scotland, land and buildings transaction tax, in Wales, land transaction tax, would apply to that. So again, if there's any kind of property interest being taken, they might apply. That was obviously a very, very quick run through a number of the key tax implications. There are a host of other kind of considerations, and in some cases different rules for specific industries. You know, particularly kind of oil and gas have different different kind of tests in relation to certain aspects of the residence test and the application of tax. So I guess kind of the message is I would urge you to get advice, particularly on the rules relating to residence and scope of tax in the UK. And don't be kind of complacent with the advice that you've got. As I said, tax changes all the time and will need to continue to evolve in this ever-changing world. So do make sure you update that that advice regularly, and we're always happy to help from a UK perspective if you need it. Thank you.
Thanks very much, Christine. So I think it falls to me then to talk a little bit about employment and labour law. There are broadly two sources of rights and obligations under UK employment law. The first is statute, so of course legislation. And for those of you who are familiar with European Union derived employment law concepts, many of the concepts under our statutes, but not all of them, will be familiar to you. Although we've of course left the European Union, our domestic legislation, which derives from EU law, remains on our statute books. And I'll briefly address at the end of this section some recent government proposals for reform in that regard. The second broad source of rights and obligations is the employment contract itself. And I should say alongside that we have excuse me, a well-defined regime related to trade unions in the UK. So I would say a sizable minority of employers in the UK recognise a trade union for collective bargaining purposes. And this is particularly prominent within the public sector. So certain commitments that are set out within collective bargaining agreements, so those are agreements between an employer and a trade union. The employees themselves are not party to those agreements, but certain commitments that are set out within those documents can become part of the individual employment contract between the employer and the employee through incorporation. And trade unions are a feature of a number of sectors, both public and private. So in one of the sectors that I work most closely with, which is the offshore energy sector, trade unions have seen a resurgence in popularity over the last 18 months. This has been described in Britain as the summer of discontent, as we've seen strikes taking place across a number of sectors in relation to pay disputes. And whilst our legislation means that trade unions have to go through a really rigorous balloting system and command a significant majority of support amongst the workforce before they can call workers out to strike, trade unions have been achieving those levels of support in recent times. Trade unions and industrial action is a whole topic in itself, and I'm not going to get into that. I just really wanted to touch upon it. So the final thing that I'll say on that is that we have a statutory scheme which in certain circumstances allows a trade union to force an employer to recognise it for collective bargaining purposes. So in other words, the trade union can go through a process whereby it forces the hand of the employer to bring the trade union to the bargaining table when it comes to things like employee wages, working hours and holidays. But to force that recognition, the trade union needs to jump through a considerable number of hoops, and it must be able to demonstrate that it has support from a majority of the workforce. So securing forced recognition for trade unions is certainly no mean feat. It doesn't happen all that often, but it can happen. And as I say, particularly in recent times with the increase in popularity of trade unions, we are seeing it in a number of sectors where we haven't seen that previously. So if I can just skip on to the next slide there. So the very first thing you need to think about when you're going to be engaging personnel to work in the UK is what you intend their employment status to be and what it will be. So on the left-hand side of the slide there, I've referred to status, and broadly speaking, individuals working in the UK will fall into one of three categories. And depending on the category, the individual will enjoy different levels of rights and protections, and they may also be taxed differently. So it's important to determine at the outset which category an individual will fall into and for their contract to reflect this, but it's also important to continue to monitor that because to borrow a phrase that Christine just used, it's more about substance over form here. So our courts and tribunals, when looking at what category an individual falls within, they're not solely going to be influenced by what the contract says. They will be influenced by what happens in practice. So the three broad categories are employees, workers, and the self-employed. And in simple terms, employees in the UK enjoy the widest range of rights and protections. So they benefit from all of the rights that I'm going to talk about today. Workers, the next category, have many of the entitlements but miss out on what I would describe as some of the big ticket protections, such as for unfair dismissal, which I'll come on to discuss. And then final broad category is the truly self-employed, so people who are truly operating in business for themselves, where their relationship with the third-party company is one of business to business rather than master and servant, as we kind of tend to refer to the employment relationship as. So determining what status an individual falls within can sometimes be tricky, and it's an area where we've seen calls for simplification and reform. The government a number of years ago conducted a wide exercise of reviewing employment legislation and seeking recommendations as to areas for reform, and status was one of those that was really, there were really a number of calls for the law to really, I suppose, catch up with the system of work and the economy that we see today. So, as I said, when determining status, it's not as simple as setting out in the contract what status is agreed between the individual and the company. The central concept in determining which category an individual fell within used to be determined solely by looking at what we call mutuality of obligation. So in other words, is there an obligation for the employer to give the individual work? And is there an obligation for the individual to accept that work if it's given to them? And if the answer to both of these was yes, then the individual would generally be regarded as an employee, sometimes as a worker if that was slightly diluted. But now the courts and tribunals will look at a much wider variety of factors when determining this. And broadly, what they're trying to do is assess the level of control the business exercises over the individual to determine what status they fall within. And like countries around the world, the rise of the gig economy in the UK has, excuse me, led to a series of class actions in our courts where individuals had been engaged by companies like Uber sought to challenge their status. So under their contracts, Uber drivers had been classed as self-employed workers, which meant that they wouldn't benefit from many of the protections that I'm going to come on to talk about. However, they succeeded in arguing before our courts that they should be regarded as workers, meaning that they unlocked rights to things like paid holidays, the right to receive pension contributions from their employer when their earnings were above a particular level. So this is a real area where we've seen a lot of litigation in recent times, and there may well be change. The next thing I've mentioned on the slide is the entitlement to an employment contract, a written employment contract. This right applies to both employees and workers. And this features under our Employment Rights Act 1996, which is really the central piece of legislation containing employee and worker rights. It doesn't deal with discrimination. That's in a separate piece of legislation I'll come on to talk about, but the Employment Rights Act is really quite central to a number of the things that we will talk about. And so under the Employment Rights Act, a written contract must be delivered by the employer no later than the beginning of employment, so on day one. And section 1 of the Act I refer to sets out what the contract must contain, and it's the things that you would expect. So basic information about working hours, salary, holiday entitlements, sick pay entitlements, pension and benefits, and those sorts of things. It's important to stress that there's no standalone claim that can be brought by an individual for failure to provide them with a contract. So it's something that they would have to piggyback on another form of litigation. The final reference on the slide there to working hours and pay. So the key piece of legislation there, excuse me, is the Working Time Regulations 1998, and this implemented into UK law the terms of the EU Working Time Directive. So this covers a number of areas, working hours, and rest breaks, rest periods, those sorts of things, and also time off, holidays. So the first point that I've noted on the slide there, generally employees cannot be required to work in excess of 48 hours a week on average, but an exception can be made when the employee consents to opting out of this maximum limit. And we see that happening quite often in practice. And as I say, the industry that I most closely work with, the offshore energy sector, that really happens almost as a matter of course because of the working arrangements that apply in that sector. The regulations, as I say, also contain requirements related to mandatory daily rest breaks and weekly rest periods for workers and employees, although special rules apply to some sectors such as offshore energy, which entitle employers to offer compensatory rest in lieu of the rest periods set out under the regulations. There's an obligation under those regulations for employers to record the hours and days that are being worked by their employees and workers so that compliance with the regulations can be monitored. But historically, there's a suspicion that many employers don't follow this as rigorously as they should. So again, this is an area where there's been calls for reform and greater tightening of practices. Employees, but not workers, with at least 26 weeks of continuous employment are entitled to request flexible working arrangements. So the request can be made for any reason, but must be submitted in writing. And essentially, this is a request to vary the contract of employment. So to vary the hours of work, the days of work, or indeed where an individual works. And where a flexible working request is submitted, the employer must respond to that within 3 months and can only refuse the request on one of 8 specified reasons. I've mentioned finally on that slide the National Minimum Wage Act, which applies to employers and workers, which sets out a minimum hourly rate of pay, which must be applied by employers. And as you can see, there are slightly different categories for different categories of employees and workers. So if I can just go to the next slide there, please. So dealing with time off, again, paid holidays are set out, the entitlement to holidays is set out under the Working Time Regulations, and under those regulations, workers and employees in the UK are entitled to a minimum of 5.6 weeks annual leave in each year, which translates to 28 days for an individual who works full-time, so 5 days a week, Monday to Friday. This 28 days includes public and bank holidays, so they're not on top. But of course, it's open to employers to offer more generous holidays if they wish to do so. And in practice, we see that quite frequently. This is an area where the UK has gold-plated the requirements of the EU Working Time Directive. So the Working Time Directive only requires 4 weeks or 20 days, but we've topped that up with an additional 1.6 weeks. There are also numerous types of family-related time off and pay entitlement within the UK, and I've listed some of those on the slide. So just run through some of the kind of the bigger hitters there. There's an entitlement to 52 weeks of statutory maternity leave. And for employees with 26 weeks employment, 26 weeks continuous employment with their employer, they're entitled to receive statutory maternity pay. The statutory levels are 6 weeks at 90% of their normal earnings, followed by 33 weeks at the prescribed rate, which is currently just £172 or thereabouts. There's a total of 39 weeks, which an individual going on maternity leave is entitled to be paid. Again, an employer can top that up, can make their own scheme more generous, and that happens quite often. Again, with adoption leave, an entitlement to 52 weeks leave, and then the rules around pay largely mirror those which apply to maternity leave. Some of the others that I've mentioned on the slide there, I won't run through in detail, but we've had a number of pieces of legislation recently receiving approval through Parliament and gaining royal assent. So we're going to see legislation very soon introducing up to 12 weeks of paid neonatal care leave, a new entitlement for unpaid leave for carers, and also enhanced protections for pregnant women and new parents around redundancy. So in situations where there's a downturn in the business and we're making layoffs, redundancies, additional protections for pregnant women and new parents. And I should add that for the majority of these types of family-related time off, the right to receive pay only applies to employees and not to workers. And I've mentioned just at the foot of the slide on the left-hand side, the entitlement to sick leave and to statutory sick pay, which applies to employees and sometimes to workers as well. And that can be a right to up to 28 weeks of pay at a statutory rate. Again, it's not a huge sum of money, which is payable from a weekly perspective. And regularly we see employers top that up with more enhanced, more beneficial contractual schemes. So protection from discrimination, like most jurisdictions, we've got a sophisticated system of protection from discrimination, and these rights apply not just in the employment arena, but in the arena of supply of goods and services and access to public services and so on. But within employment, employees and workers have the right not to be discriminated against on grounds of any of the 9 protected characteristics I've listed on the slide. And this protection extends beyond the period of employment. So it covers job applicants and even employees whose contracts have ended. So for example, those who are seeking to receive a letter of recommendation or a reference from their former employer, if the former employer writes a poor reference or withholds a reference on discriminatory grounds, then the individual has the ability to bring a claim. These rights may also apply to certain self-employed individuals, so it certainly applies to employees and to workers, but the self-employed may also be covered under the contract workers provisions of our Equality Act. Enforcement of discrimination rights in the employment arena is through our employment tribunal system. So individuals who consider themselves to have suffered discrimination at the hands of their employer. I think maybe somebody's come off mute there. Can I just check everyone's on mute? Sorry. So as I was saying, individuals who consider themselves as having been discriminated against have the ability to raise claims in our employment tribunal system, and there's no minimum period of employment that they have to have before they have the entitlement to bring that claim. And also there's no cap on the potential compensation that they can be awarded if their claim succeeds, but it is a compensatory system. So it only compensates for loss and for injury to feelings, and it doesn't seek to penalise employers for discrimination. Important to mention health and safety. So employers in the UK have statutory duties to take measures to ensure the health, safety and welfare of employees and others affected by work activities. To achieve this, appropriate procedures and measures must be implemented in the workplace to prevent and control the risks. And then if an employer's workforce consists of 5 or more employees, then risk assessments and relevant control measures must be recorded in a written document. Employers are required to have a written health and safety policy and liability insurance in place. And it's very important to note that a failure to comply with health and safety duties is a criminal offence, which can lead to substantial financial penalties for businesses and potentially imprisonment for individuals. Finally, on the slide, I will mention business transfer protection. So employees in the UK enjoy specific protections in relation to transfers of undertakings under our transfer of undertakings protection of employment regulations, which we refer to as TUPE for short. And these regulations implement the terms of the EU Acquired Rights Directive. So what these mean is that where a business or part of a business is being bought or sold, then the relevant employees of that business or part of that business, their employment may transfer to the purchaser, and they transfer on their existing terms and conditions of employment with their continuity of employment preserved. And this is another area where the UK has gold-plated the EU rules by applying this principle to service provision changes, not just business transfers. So I'll explain what I mean by use of an example. So the building that I'm sitting in, the building owner outsources the provision of security and reception staff to a third-party service provider. And if the building owner decides to terminate its contract with the third-party provider and appoint a new third party to manage security and reception services, then any employees currently assigned to the security and reception services may well transfer to that new third party. And many businesses don't like these rules because often part of the reason for wishing to replace a service provider is a bad level of service from the individuals who are involved. So the fact that they then transfer and remain with the business can be a source of frustration. So this may well be an area where we see development and change now that we've left the EU. Where the TUPE rules are engaged, so where individuals transfer, then they're protected from dismissal and from having changes to their terms and conditions imposed upon them. If I could just click to the next slide, please. So just to wrap up my section then, I will talk about termination. So what happens, what are the rules at the end of the employment or worker or self-employed relationship? So employees in the UK, just employees, not workers, not self-employed, enjoy rights which relate to termination in addition to those set out in their contract of employment. So in order to fairly terminate the employment of an employee, an employer must be able to point to one of 5 statutory reasons as the basis for termination. And those 5 reasons are conduct, capability, which includes performance or ill health, incapability, redundancy, what's known as statutory restriction or illegality. So that's to I guess follow on from Nikki's point, where someone loses their immigration rights to be in the UK and to work in the UK. Clearly the employer cannot lawfully employ them anymore, and so a termination of a contract is permissible on those reasons. And then the final class is some other substantial reason, which is a bit of a sweep up, but there's very limited circumstances in which this can be used. And as well as being able to point to one of these 5 reasons, an employer must be able to demonstrate that it acted reasonably in treating that reason as sufficient to justify termination, and that it followed a fair procedure before dismissing the individual. So these rights apply just to employees, as I say, and it's also important to bear in mind that it's only employees with a minimum of 2 years continuous employment who can bring a claim before an employment tribunal for unfair dismissal. So where they argue that they've been terminated in breach of these principles. So only employees with 2 years service can generally bring unfair dismissal claims. those claims can attract a maximum level of compensation. The maximum compensation level is currently set at £105,000 or 52 weeks pay, whichever is lower. So if an individual's salary and benefits value over a 52-week period is, say, £100,000, then that's where the cap is set. If it's above £105,000, then it's at £105,000. And the rules have a little bit more complexity than I'm explaining. So for example, there are some forms of unfair dismissal claim where there's no requirement for minimum years service and where there's no cap on compensation. So for example, an employee who's dismissed for blowing the whistle on breaches of legal duty or for unsafe working practices, there's no cap there. Our statutory claims are generally enforced in the employment tribunal, and the principal remedy that our employment tribunal can award in cases of unfair dismissal is reinstatement or re-engagement, but we rarely see that. It happens in less than 1% of cases. So it's generally speaking compensation that we see awarded. I've mentioned a couple of other points on the left-hand side of the slide, which I won't run through in detail, but it's just important to bear in mind that the rules that I've mentioned are the kind of statutory rights around termination. Employees, workers, and the self-employed, where there's a termination, will also need to be terminated in compliance with their contract of employment. So if there's notice provisions in there, etc., those need to be followed. And finally, on the left-hand side of the slide, I've mentioned consultations. So in certain situations, there is an obligation for employers to engage in collective consultation. So consultation via appointed representatives. So for example, where there's a proposal to dismiss as redundant 20 or more employees, there are collective consultation obligations. Very, very quickly, because I'm conscious of time and I'm leaving minimal time for questions here. On the right-hand side of the slide, post-termination issues, we have a sophisticated system which relates to restrictive covenants. So post-termination restrictions, they are permissible in the UK, provided they're no wider than reasonably necessary to protect the interests of the employer. We've had recent announcement from the government that it intends to bring into force restrictions on non-competes. So there's restrictions that would prevent an individual from joining a competitor. The government has announced that it is going to limit those to 3 months. And I've mentioned settlement agreements. That's just one of the systems that we can use to discharge employment claims. So if we can just flick to the very final slide from me, I mentioned reform at the outset. Some of you who pay close attention to the political landscape in the UK may have heard of this bill. So this was introduced by the Conservative government last year. The big news was that it had a sunsetting clause, which would have meant that all EU-derived legislation would have fallen off our statute books on the 31st of December this year, unless specific measures had been taken by the government to retain that legislation or to introduce amending legislation. The big news item is the government has sensibly decided to reverse that. So we're now no longer going to see a wide falling off of our statute books of EU-derived legislation. And apologies, that is the fire alarm test running off in the room. But that brings me to a close there. I'm conscious that we had this session in the book just until 11, but if anyone does want to stay on for any questions, then you are most welcome to. I will mute myself there and allow questions from the floor. I don't think there are any in the chat box, but we'd welcome them if anyone has any. I'll take from that no one has any questions. I'm conscious that we covered an awful lot of content during that discussion, and we tried to speed through things. As I say, we couldn't possibly cover everything in detail within the time that we had allocated, but hopefully that was interesting and of use. I think what we'll do after this session is send out the slides to delegates, and I'm conscious our email addresses weren't on those slides, so we'll include those. And if anyone wants to, follow up with any of us directly, then please feel free to do so. I think final thing for me to say, as I mentioned at the start, look out for our guide on doing business in the UK, which we should be publishing relatively soon, and we'll ensure that a copy hits all of your inboxes. And then finally from me, big thanks to everyone for attending this morning, and I hope you have a fantastic rest of the day and into the weekend. So thanks very much.